Hi, I'm Mike Benoit, and I want to give you a little information today about IRS tyranny, a personal case of mine where the IRS and the United States government is stealing my house through the courts, of course, and claiming that I owe taxes, which I don't owe. I'm going to go through the case, try to cover it in a half hour, try to do it in such a way that it's not too technical for the layperson to understand, to get the gist of this. And so just expose tyranny for exactly what it is, and it's quite simple tyranny here. The case number, in case you want to look it up on the, what do you call it, PACER, the legal records website. It's a Southern District of California, United States District Court. Case number would be 308 CV 02140. You can find it that way. We start off with the United States complaint, which they filed in late 2008, just before I guess the statute of limitations would have run out, 18th day of November. And this is for alleged taxes owed for 1995 and 1996. And I answered the complaint asking for a jury trial, of course demanding a jury trial, denying all the allegations. And what else? I'm going to go through this thing folder by folder and make a point. They also sue in the process the lien holder or the lender of record. And that's really kind of a funny, bizarre way of doing things. They sued also the state of California. Now this is the IRS suing me for alleged back taxes, and suing the mortgage holder, and suing the state of California. It's an interesting way that the state of California becomes actually an additional plaintiff. And so I don't know what kind of legal farce or fiction this is, but they're listed as a defendant, but they have a claim for the same years of alleged taxes being owed. So they're brought in as an additional defendant, but in the process they're acting as if they're acting as another plaintiff against me, creating another lien on the property, or trying to get their fair share what they're alleging here. Now I'm reaching over for folders, so forgive me on that. And I should have the docket here instead, but I'm just going to flip through these things real quick. And they got the standard little procedure. They got their discovery plans, case management, all that, instructions from the court. So you go through the motions here, and in this folder I don't think there's much to pay any attention to. Okay, so we're going to use this document list. It's going to be a lot easier way of explaining the sequence of events here. Okay, as the court lays out joint discovery plan that we're supposed to follow, and in that process I propose interrogatories and propose production of documents, and so does the government. And let's see, the first thing that becomes kind of important here on this list. Oh, well, in this process, the United States government filed a joint motion with the other defendant, the state of California, and they claim that the United States government has priority over the state of California. And of course, I wasn't involved in that so-called joint agreement, and I objected to that because how could you state that the United States has priority over a claim that's not even adjudicated? Maybe the United States' claim was bogus and the state's was not bogus. So, but that's a little thing that they do in the process. And next thing, I needed more time, so I filed a motion to stay proceedings. I didn't get anything on that. Let's see. Next item of significance, we'll find it here. All right, joint discovery dispute. I had presented a dispute to the court, whereas the government didn't answer my interrogatories and my production of documents. I asked for things like production of assessments, record of assessment, and other documents. And the key thing that I asked for was underlying code section that made me liable for taxes. And the government did not answer that question. Basically, they said to the court, they said that the code is public record, that Benoit can find these things as well as they could, etc., etc. Well, the magistrate judge said that that wasn't going to stand. He wanted the government to show me the underlying statute that created the liability. So I thought I had something here because I knew they couldn't find that. And what the government responded with on that was an answer that they posed a totally different question to the question that I posed. The question I posed is, please state the code section that imposed the tax on me. And their answer was, here are the code sections that relate to this matter. So they didn't answer that, the interrogatory as it was posed, and they listed about 9 different code sections. Several of them were just definition code sections. But the court allowed that and accepted that. So next thing that happens is the government files a motion for summary judgment. So if you don't know what that is, summary judgment basically is a decision where both parties do not dispute the facts. There's no dispute in the facts. There's simply a disagreement over the law. And this is a real huge example of tyranny by government and the government courts. Of course, it's citizen against the IRS government with a government judge. And so I'm disputing that I owe this money all the time, and I'm disputing several points of issues within the case. Well, the IRS, of course, is going to claim that there is no dispute over the facts. IRS is going to say the facts are Mr. Benoit had income, and the facts are Mr. Benoit had taxable income, and the facts are that Mr. Benoit didn't file a tax return, so the facts are he owes money. And of course I say that I didn't have income, I didn't have taxable income, and I don't owe any money. Well, on the summary judgment process, of course, the IRS gets to use a form that is called a certificate and record of assessments, and on that form they get the presumption of correctness that the form is correct. So in other words, they can march in and say, here, this form is correct because look here, it has all these things listed on it. So these are the facts. They present a form actually that was issued in the year 2006 for taxes of 1995 and 1996. And all the times I've gone over this thing, right now I can't remember the form number. I think it's, I'm not even going to say it's IRS Certificate of Assessments and Record of Payments. So, and of course I file my own motion for summary judgment, basically saying that since the government cannot produce a code section and cannot produce assessments, and all they can produce is this certificate of assessments issued something like 10 years after the so-called alleged liabilities, that they don't have the condition that's requisite to a dispute. There is no issue in dispute, and I'm asking for summary judgment in my behalf. Now, what's foul about the summary judgment process is that you don't get a jury trial. So, in essence, the judge says and the court says on this thing is that you don't get this jury trial because we find that there is no facts in disputes. And the truth is, there are facts in dispute, but all they have to do, the judge has to do, is claim there are no facts in dispute. And of course, I want to this whole case in front of a jury, because the jury is supposed to determine the facts. But if the judge says, oh, this can say no facts in dispute, of course there's facts in dispute. The IRS wouldn't produce a record of assessment, not a record of assessment, but the actual assessment, the code section that created the liability. In addition to that, there's some penalty sections that require someone to be negligent before they can be imposed. And so, as long as there's some material issue that would present a case of disputed facts, that there are disputed facts, then you're entitled to a trial by jury. Well, I'm fighting in this process to get that trial by jury. And obviously it didn't happen. So we move on down the line with this, and the government gets their summary judgment against me. So it's basically saying that they can take my house and throw me out of it based on all of these things and based on the fact that I didn't get a trial by jury. Now, I don't know how you're reacting to this. You're saying, I should have paid his taxes, whatnot, or they're saying, or your reaction is, hey, this is totally unfair. Everybody deserves their day in court, especially going to take their house away from them. So we go through that process, and I'm thinking I got enough information to show that their presumptive evidence of their certificate of assessment is a Form 4000 something, almost remembering it, that I got enough to show that there are triable issues, that there are disputed facts, and especially on these penalties that were charged, because these penalties to be charged requires that a person be negligent in the process. If I'm saying all along that I don't owe these taxes and show me where I owe them and produce records of assessment, and I'm saying this for 10, 12 years, and the government, IRS, doesn't produce these things, then how can someone claim that that's a condition of negligence? And whether somebody was negligent or not is an issue of fact, and it's the trier of fact or the jury that decides whether or not that there is a dispute on the facts, and decides the facts on one party in one party's favor against the other party. So, but I'm not getting this, and it's not working out for me. And so what I do is I file a notice of appeal, and I file appeal to get the upper court, the higher court, to take a look at what transpired in the earlier court and get them to say, hey, there's definitely disputed facts here, and give the guy his trial. But as we move along on this thing and I get deeper into it, I discover something else, and this something else is the code section. I believe the code section is 6662. Maybe I'm getting that number wrong, and I'll show you the documentation on that in a letter. But under this code section, it states that it's an accuracy-related penalty, which was listed on these forms early on from the beginning, and they charge a penalty for accuracy. Well, in this case, I didn't file taxes because I didn't owe any taxes, so there's nothing inaccurate whatsoever. Well, I discover treasury decisions, I discover Code of Federal Regulations or Internal Revenue Manual and Internal Revenue Code sections that make it clear that you can't charge, the IRS cannot charge accuracy-related penalties on a case where there is no tax return filed by the taxpayer. Those penalties don't apply under those conditions, because it's kind of common sense, but there's all these treasury decisions and Code of Federal Regulations, Internal Revenue Code, the Internal Revenue Manual that point this out in addition. Now, I didn't have that in to argue during the actual summary judgment motion, because that was sort of uncovered as if I got into this thing further. But the key and important thing about this new information was that this information, certainly, because it was new to me, but the government should have known it all along, because they're the ones doing it. They're charging penalties for under a penalty section they're not allowed by law to charge. And in that process, what you find is under this section that there's another section in the Internal Revenue Code that relates to charging more than is allowed by law, or oppression of the taxpayer under the color of law. This section is 7214. It makes it a felony to try to attempt to collect more monies than are lawfully that are allowed by law. And so these agents are committing a felony under section 7214. And again, this isn't a speculation where I say I don't owe, they say I do owe, and there's a dispute on reading the law. When I bring this up, and I bring this up in my appellate motions, and I bring it up in other motions, when I bring this up, the government stays clear of addressing this point whatsoever. So if it is true that under this code section that they were charging accuracy-related penalties, and since the beginning of this issue, back in 1995 and 96, then they were violating section 7214 of the Internal Revenue Code, and because you can't charge accuracy-related penalties. So this is just one thing on top of the layer of things in this case. But further in this case, another piece of information comes up that the attorney for the United States was not an actively barred attorney. Her license was an inactive status. And so as an attorney under these tax matters, the attorney is not only acting as an attorney, but is acting as a sort of as a party as well, submitting answers to interrogatories signed under the penalty of perjury, and signed as if this person is an attorney. Now, I filed motions to be relieved of judgment on the basis that this person was not authorized to submit any evidence to the court, and the rules prohibit anybody submitting evidence that's not authorized to submit such evidence. So the evidence would, basically would negate any of the evidence. So we have this unlicensed person practicing on behalf of the government, and something that's prohibited by law, and then the case still stands. Beyond that, the case, the decision was it's okay, and they come up with some flim-flam reasons why it's okay, but it's absolutely material to the evidence presented or submitted. But I take this information on the 7214 violation, and I inform the judge, I inform the United States Attorney, and I inform everybody involved that this is a violation of the law. And I got the letters for this, I'll show you the letters, and that's a felony. And you would think, and then it's also would be a crime against me, I think it's called misprison, if I didn't submit this evidence to the court. And you'll be able to, we're going to show you this different information in different code sections, and you'll see what we're talking about here. But now this case is still, it's in the Ninth Circuit right now, and the whole process, I'm wondering, how can this possibly continue when the documents that they gave some presumptive correctness to, that were issued in 2006 for the first time, and this is considered evidence, that on these documents it shows an assessment for this code section, accuracy related penalty, I believe it's 6662, an accuracy related penalty for someone who didn't file a tax return, and all the laws state that accuracy related penalty does not apply to somebody who does not or did not file a tax return. You're not going to say they're inaccurate. Now, if they're required to file a tax return, sure, you could charge them with penalties for failure to file a tax return or that sort of thing. But there's plenty of evidence that shows that when you don't file a tax return, you can't be charged with accuracy-related penalties. And that's the crux of this thing. And this thing should have been done from the get-go. Not only did it, there's serious consideration here about there was enough evidence that a person should get trial by jury instead of a summary judgment against them to take away their house. But when you look at how polluted it was from the get-go on the accuracy-related penalties that were charged, interest piled on that, and this is all in violation of Section 7214 of the Internal Revenue Code. All these people that are involved in this and that know about this right now are complicit and still continuing to try to collect more money than is lawfully allowed by law. It's cut and dry. It's not, you might say, okay, this guy owes some taxes, he didn't pay any taxes, and that's an issue, one thing. But another thing is to pile all these penalties on that absolutely, unequivocally do not apply, and it's a fraud, and it makes the documents fraudulent from the start. So that's basically all we're going to give you right now. We're going to show you the documents. The key information here is, one, that there's a dispute here, no trial by jury, that the IRS did not produce the code section that imposed the liability from the beginning, did not produce assessments, that the court said, okay, we're going to take this record of assessments, Form 4043, I believe it is, hope I got this number right now, and we're saying, I probably got that number wrong, but anyway, yeah, we'll have the form on the in the evidence documents here, and you'll see what we're talking about, that this form issued in 2006, and in this case we got so many other things. We got another form issued in 2007 that's different than the one issued in 2006, and these things go all over the place, but this is for alleged taxes of 95 and 96. But all of this confusion, the bottom line is, this, again, is so polluted with trying to charge penalties and interest on penalties for an accuracy-related situation. The code section absolutely does not apply to that, and plenty of documentation that says that this thing should have been just killed from the get-go on that basis alone, but yet it's still hanging over me, and every day I wonder when the IRS is going to reach down, take my house without trial by jury, and on bogus, fraudulent documents. So that's all for now on this. We'll have a follow-up later.